My name is Colin Gonsalves. I'm a lawyer from India, and I'm the founder of the Human Rights Law Network, which is a network of about 20 offices and 250 people, lawyers and paralegals and social activists. And what we do is to provide legal services for the poor, for the oppressed, for those who suffered repression. But we are not just a legal office, we are a combative legal office in the sense that we go out to places where oppression is taking place and we engage in struggle. We do the legal aspects of the struggle, but we participate in the struggles of the poor against all kinds of repression. So we are quite a combative organization. The only thing is that our weapon of combat is the Constitution of India, and we use our legal system, which is a very virile legal system, a very strong and innovative legal system of public interest litigation, class action litigation, to fight for the poor. I'll give you the example of the mass sterilization of women in the family planning program, where in the rural areas and the remote parts of the country where the media doesn't reach, the women, poor women in the villages were herded into abandoned schools, abandoned hospitals, and the tables were dusted. And the women were taken into these schools, made to lie on the tables, and they were sterilized with one laparoscope machine for 100 women, and they would go body to body, doing the laparoscopy operations without cleaning the sterilization laparoscope, without changing gloves. And many women died in this process right across the country. Many women had all kinds of very serious ailments and sicknesses after that. And we took these cases to the Supreme Court, and the Supreme Court said no more doing sterilization operation in camps. You will do it only in the official hospitals. And you will do it with doctors that are accredited, who are on the list of official doctors. And you will not use a laparoscope machine for more than 20 operations in a day. And you will sterilize the instrument every time, and you will change your gloves and so on. So it was quite a reformation of a very cruel aspect of the family planning program, which was stopped by the Supreme Court. The Constitution grows as society grows. And so the courts have been very instrumental in interpreting the Constitution in such a way that the Constitution kept growing. For example, we don't have the right to food in our Constitution. We don't have a right to a healthy environment in our Constitution. We don't have the right to education, the right to housing. And the Supreme Court, when it came across such cases, it interpreted Article 21 of our Constitution, which is the right to life, as including the right to a healthy environment, sustainable environment, the right to food, the right to public health care, the right to housing, the right to reproductive rights. So the judiciary has been responsible for giving this Constitution new life from time to time. And that's why if you look at the Constitution and the judgments of the court, I would say on public interest litigation it's the best in the world. What we are trying to do really now, and this is the reason why DKA, Austria and others are talking with us, and we are having a discussion with them, is because we are trying to work on a global initiative of the developing countries to use their systems of constitutional law in a unified way. Today it's sporadic. India, Nepal, Pakistan, Colombia, South Africa, etc. What we are trying to do is, while we recognize that it's a revolutionary system, not just an idea, but the practice itself has been very productive. So we are trying to maybe harness this gold mine of a different way of doing law for the poor, and bring them together in what is called the Center for Constitutional Rights, which will teach these kind of practices and leading judgments and best practices, and bring them together in an institute that will train and promote the doing of public interest litigation in the developing world. I see no reason why what we speak of as collective rights and public interest litigation, I see no reason why it can't be used in a developed country situation. It's just that the minds of the judges and the professors are a bit stagnant, and they are too caught up in the past, and they have nothing to say for the future. So I lose heart and I lose hope when I hear them lecture and I hear them speak. And they act as if what the developing countries are doing is some crazy stuff. It is crazy, but it's good crazy. And they're not crazy. They're not alive at all. It's like dead crazy. They're just dead. So we are crazy, we admit we are crazy, but we are good crazy and we're getting good results, and the poor are getting benefits from the courts, and the courts are enjoying giving orders for the poor. So what's wrong with that crazy? It's good to be crazy sometimes.